Welcome to the Mendoza Podcast, financial talk that makes sense. I'm your Illinois State Controller, Susana Mendoza, and I want to help answer all the questions you have about money matters, but we're maybe afraid to ask. We're going to learn a lot and have some fun together. Welcome back to the Mendoza Podcast. Today we're going to talk about planning, estate planning, that is. No one wants to think about dying. But this is about ensuring your money and possessions go where you want them to go when you're gone, and making the process after your death as easy as possible for your loved ones. My guest today is Cindy Campbell, an estate planning attorney and managing partner at Concierge Law. Cindy, thanks so much for joining us today.
Yes, thank you for having me.
It's great to have you. So why don't you tell us a little bit about yourself and your actual practice?
Okay. So I am a managing partner and CEO at Campbell Holzhauer Concierge Law, where we offer ongoing services, legal services to our clients for families and business issues. That includes estate planning, wills and trusts, and all of that kind of stuff. I also published a book, Legal Things Parents Should Know, with occasional wit and sarcasm that delves a little deeper into some of the topics we're going to talk about today.
Yeah, and it is very light. I mean, it's a fun book to read if you can think about something of this serious of a nature, trying to make it fun and lighthearted. So thank you for that. I've read it. But let's dive right in. I mean, what exactly is estate planning? Assume that the folks watching this don't know much about it, if anything at all. And are we talking about, when we think of estate planning, things like having a will or like deciding who gets your china or what? I mean, walk us through that.
Yes.
Yes, to all of the above. That's it.
But all of it, really. I mean, we are talking about a will. Estate planning includes your estate, whatever that means. That can be your china, that can be your money, that can be your land. That's all included in your estate.
Yeah, an estate doesn't mean you have to own a house.
Right.
It could just be like anything, to make that clear. Because I think a lot of people think estate planning, I don't need to worry about it if I don't have like my own home or I don't have lots of big possessions.
Yes.
Literally, it could be just something of real value to you.
Yes, your assets. If you have some assets, you have an estate, and you should do some planning with it.
Very good. So what are the differences between a will, which I think most people have heard of, and a trust, which people may have heard the name, but they don't necessarily know what it means? I mean, what's the difference and who needs what?
So a will, I say, is essentially instructions for the court. Okay, so it tells the court, when I pass, this is who I want to handle my estate, this is who I want to wind it up, and this is who I want it to go to. Also, very importantly, it names a guardian. So if you have minor children, that's very important. Depending on the size of your assets and or the complexity of your estate, it may make sense to also include a trust with your will.
And what is a trust?
Yeah. So, a trust can be revocable. It can be irrevocable. But I like to say, think of your trust like a shell that it's like this sort of fictitious entity in a revocable trust that doesn't become irrevocable until you die. And we put your assets in it now while you are alive and have capacity. And it says, upon my death, this is who I want my estate, that going back to the estate, to go to. The nice thing about a trust versus just a will is that you can allow for more complex distributions.
Give me an example.
Okay. So let's say I have two children, and one child is has some issues, some substance abuse issues.
Okay.
And one child is the opposite and very financially responsible and has that, that straight A student, and the other one is struggling a little bit in life. So maybe instead of just my assets going outright to my children, in this scenario, in this hypothetical, let's say they're adults. Instead of it going outright to them, let's say I want the one child to receive their inheritance outright, but I want the other child, I want it to be managed. I want to make sure it's being used wisely. I want to make sure they get on their feet and that, someone is there if I pass away to kind of help care for them and make sure that they're not just receiving this money and it's all gone.
And so that's different from a will in the sense that a will would just distribute the things according to whatever the percentage is. But a trust would mean that maybe the one child is you trust that they get the money all in one hit because you trust how they're going to be utilizing it, and I'm play on words here.
Yep.
Whereas the other child or the other adult but who might not have your trust to make good use of that money, there would be someone else that would be potentially, you could assign someone to be releasing certain percentages of money, let's say if they meet certain milestones in their lives.
Exactly.
Okay.
And so similarly, I also use this for minor children. And so in my scenario, I have young children. And so I have named a trustee who is the person who would step in and manage the estate for the benefit of the beneficiary. So let's say those are my children. I've passed away. The trustee steps in and I have contingencies in place. Like, so once they reach age 22, they can receive a certain amount. As they get a little older, they'll receive a little bit more. And then they get more at age 30, and then it goes on. The idea is that if I gave, I mean, my children are only 10 and 13 right now, but I just foresee that if they received everything at 18,
they're not ready.
I don't think.
Right. Most kids wouldn't be at 18 ready to, know how to manage a certain sum of money that comes their way. So I think that's a really smart way of doing it.
Right now, it would all go to Fortnite skins and Roblox.
100%. Or Minecraft stuff. Yes, exactly. You're right. So at a bare minimum, though, what should we have in place?
So at a bare minimum, I would say powers of attorney are so simple and easy to put in place as long as you have capacity. And they are such an important document. That's the document that says, if I become incapacitated, who can step in and get access to my bank account, make sure that my rent gets paid and my utilities get paid. So I say everybody needs that, even at age 18, right? Because you never know when you're going to become incapacitated.
Sure.
It could be a car accident.
That's interesting to think about, because I think, even the responsible adults think about, okay, I need a power of attorney, or I need a trust, or I need a will. I mean, we've had to do that in my household. But I don't know that I thought about, like, when my son becomes 18, he needs to get one. So thank you for that tip, because he will be doing so when he becomes 18. Because to your point, I mean, it's like the things that are important to him, if he were to die and not have that in place, we don't get to make those decisions anymore, because he's technically an adult under the law.
Yes, and that is one of the biggest areas that I want to encourage parents when their child becomes 18. They don't think about it. But if they're in a car accident, not only financially, but medical decisions.
Sure. So the parents wouldn't have the right to make a medical decision?
Not necessarily.
Really?
Yes. And if you think about it, the hospital, they don't know what that relationship is like.
Right. But that's crazy.
Now they're an adult.
Yeah. So
they are just an adult.
That
and
is
so
super
you're
scary.
coming in trying to force your opinions on somebody else. And so they take it very seriously and do not just let even though they're the biological parent.
Wow. That's really, really, I'm like, I'm shocked.
Yeah.
It makes sense, I guess. But I mean, really, no one talks about this stuff, which is why I'm glad we have you on the podcast today. So, if you do have a child who's 18, like as soon as they turn 18, I know it sounds crazy and it sounds almost, macabre to think this way, but it's smart. It's smart planning. And it's in their best interest. Our job as a parent is always to protect our kids. And I don't care if they're 18 or 28, they're still our babies. So making sure that you're still in the driver's seat with their permission to make these really important critical decisions regarding their quality of life, should the unthinkable happen, is more important than ever. So thank you for that. It's not fun conversation, but it has to be had. So I just learned something new today. So
it's
thank you.
so important. Yes.
Now, what happens, God forbid, we pass away and have absolutely nothing done? There's nothing in place. There's no power of attorney. There's no will. There's no trust. What do we do?
Well,
or what do our loved ones do in this case?
So your estate would pass through what we call intestate, which just means it's going to revert to the laws of the state of Illinois, assuming...
we're in Illinois.
Yeah, we're in Illinois. And that is just going to depend on your situation. There's certain things that have to be done when somebody passes, no matter what. If there's a will in place, you need to file the will. You're going to have to pay taxes for the person after they've passed on. You need to figure out who everything is going to, wind up the estate. But I say if you have nothing in place, it's going to be the most complicated and probably not the least amount of fun.
But that's probably what happens to most people, right? Because, I mean, most people that I know do not have powers of attorney or wills or a trust in place. I mean, I talk to them all the time and tell them how important it is to have it. But even until recently, my husband and I didn't have one in place. So, and I feel like we're on it compared to most people. So this is the scenario for most people, and walk us through how difficult of a scenario this is and why you should act quick to resolve it.
So if your estate ends up needing to go through probate, it's not the end of the world. We do probate. You will get through it if you are in it, but it's going to be time consuming, it's going to be expensive, and it's going to be stressful. And that's kind of the bare minimum. And the more complicated your estate is, or if there's siblings that...
I was just going to say, if you have multiple siblings.
Or let's say mom never met with an attorney and never knew how to do proper estate planning. And let's say she just named the oldest child as the beneficiary on her accounts and told the oldest child, I want you to distribute it among your siblings. Well, guess what? That's not how it actually works.
There's nothing in writing saying that the oldest sibling can be like,
Gets
you know
everything.
what? I'm the trustee
Yes.
and I keep it all.
Yep.
Yeah. And how many times have you seen siblings going at each other and tearing families apart because of something like this happening?
More than I want to say.
It's super sad.
Yeah.
You're right. I hear about it all the time as well. Now, is it ever too early to start estate planning?
No. So like I was saying, with the young, 18-year-old young adult, do it then. Have something in place. And maybe...
You can change it like whenever you want too. But having it in place to begin with is critically important.
It doesn't have to be complicated, right? We can start with a very simple powers of attorney. And then as you build a little more wealth, we add on a will. And then as you build more wealth, we add on a trust. And then we just amend the trust.
Yeah, or as you have kids or things like that as well.
Yep. And you buy a house. Okay, great. Maybe it's time to add on a new part of your estate planning. But start with something, at least powers of attorney when a young adult becomes 18.
For sure. Now, on the powers of attorney, on the wills, on the trust, but let's start early, right? We're starting easy, power of attorneys. Do you need an attorney to get this done, or can a person do it by themselves?
You can do a lot of it on your own, like powers of attorney. I believe you can find through the state website. Wills, you can do... like there may be like legal platforms. I really want to caution on that though, because I've seen some of these that were, the person didn't really understand, like they just made a simple election, but they didn't understand what they were electing. And then they said, hey, would you review this for me? Sure, I'll review your document. And I'm looking at it and I'm like, is that what you wanted? Oh no, I didn't want that. And okay, so be careful. Or I've seen prepared their own legal documents and they weren't, executed correctly. So if you don't have two uninterested witnesses, and I prefer also adding a notary onto that as well. But the problem is if you have a document and it's not correctly executed, it's invalid. It's as if you didn't create it at all.
Wow. So this concept though that I could like write something down on a napkin and that would hold up in court, not true?
Well, in the law, there's always gray areas. So there are holographic wills. I suppose something in writing is better than nothing. That being said, going back to
You're still going to have to contest it in court, though, is the point.
Sure.
Versus it's ironclad and here are your wishes and,
But going back to the, even the online legal platforms, right? Like if you created your own document, it's better than nothing. If the options are, this is what I can do, or where I'm at a place where I can do this right now and I feel comfortable with it, then do that. Start where you're at and then build on it, because I would rather you have something than nothing in place.
Exactly. I think maybe people find it too overwhelming and they don't know where to get started, so they don't get started at all. And we want to make sure it's the opposite. Get started and then build from there.
Yeah.
Baby steps, right? Until you become an expert in this. Now, let's say I'm going to go see an attorney. What type of information do I need to have with me when I go meet with that attorney to get started?
Well, for the initial meeting, it's really estate planning is planning. So I just want a conversation. I just want to hear, what is your family situation? What assets do you have? Any issues in your family that I need to be aware of? Are you likely to inherit a big estate? oh, I have property in a foreign country. Second marriage, just kind of, it's conversational. And then come to my office, we talk about it, we talk through it, figure out, okay, what plan fits for you and your life.
So do most attorneys in this space start off by having an initial conversation over the phone, similar to what you talked about, where they're not charging you for that initial conversation, and then you charge based on what their plan ultimately is going to look like?
Well, it depends
Or what
on the
do
attorney,
most
right?
people? Yes.
Yeah. So usually for us, I just like to have that conversation first. And then I will tell you, okay, this is what I suggest and this is why, but it's up to the client. If they say, no, I just want to start with powers of attorney or just a simple will.
Right.
Absolutely fine, right? Or maybe I say, no, let's do a full trust. But then, yeah, and then I'll let them know what the fees are going to be at that point. And some people, going back to just starting, will come to me and like, I can tell they're a little embarrassed, right? Like they're like, oh, I did this online will. I'm like, so what?
Yeah.
We all start there,
It's
right?
better than nothing.
It's better than nothing.
Yes.
Let's look at that and okay, and maybe it's fine, honestly, and we're just adding on some documents to that. Or no, maybe we're starting over. But,
Sure.
come have a conversation
I
and
would
we'll figure
actually
that
say,
out.
way to go. You did something.
Right.
Because, it's certainly better than the next guy who's got nothing.
Right.
So, yeah. Okay, so what are some of the things to consider when it comes to designating someone to serve as that power of attorney? Such an important decision, right?
Yes.
So what are some of those things to consider?
Should likely be somebody who's financially responsible.
Okay, that's a very important thing to consider.
Right.
Yes.
So sometimes people have this preconceived idea that they should pick their family member, their sibling, or whomever, right? But maybe that person doesn't pay their own taxes on time.
Right.
Do you really
They're
want
not
them in
very
charge of-
organized,
Yes.
for example. Yes, they're too busy with a million other things going on in their
Right.
lives. Right.
Does it make sense? And if that's your only option, then hey, we'll put them in place, right? But this is where we can always revisit these documents.
Yes.
You didn't ask me about this, but also I always think about that with guardians. Sometimes parents really struggle with who to name as the guardian.
That was actually going to be my next question. Like, what do you do if you have kids under 18? No, I'm glad you read my mind. So this is good.
Yeah.
Look at this.
Yeah,
It's working. Yeah. So if you have kids under 18, I mean, this is like the most critical because obviously you think powers of attorney, you're thinking adults, but the most important question for any parent is like, what happens to my children if I'm gone?
Yes.
If my husband dies or we both die and our son is a minor, like that is what keeps you up at night as a parent. So like, what are those considerations that go into play in deciding who that right person is? And let me ask you this, like when you're meeting with clients and they say, I want it to be my brother. Do you ask, is your brother really financially responsible? Does he have the bandwidth to do this? Like, do you push back? Because sometimes you've seen it all. Maybe it's good to advise in the sense of just be sure these are the things that you'd want in your guardian.
Yeah, it's such a
Because it's tough, right?
emotional area. I would probably say for parents, it's probably the most emotional part of the estate planning process. But going back to, it's better to put somebody in place than nothing. It is important. Now, this is where we might add on a trust, though. So maybe during our initial consult, you say, yes, my brother, honestly, he would raise my kids the same way I would. And this is how I'd want my children to be raised. But he's also not the most financially responsible. And I say, oh, great. Well, let's pair this with a trust then. So the trustee is managing the money, paying for his health and education and maintenance and, support, making sure all his school bills get paid and all of that. He's got clothing and a house. But the brother is doing the day-to-day care.
Right.
Or let's say my guardian, I would really love to be my mom, a permanent guardian, but she lives out of state. So in the event that, and she's not close and she's older. So in the event something happens, I also want to name just a short-term guardian, someone who's here in Illinois who could step in and get my child from school, make sure I can do that day-to-day care while the permanent guardian gets appointed.
Yeah.
And again, though, this is all evolving, right? So maybe as mom gets a little older, maybe we take her out as permanent guardian.
Yes.
But we can always revisit it and change it. So put something in place.
So also you should talk to the people who you're appointing to serve in these capacities before you decide to appoint them. Because I have heard stories of like someone dies and then it's like you get called in by the attorney. You're like, congrats, you're in charge of the kids.
Yeah.
What do you mean I'm in charge of the kids? Why? Well, because your sister trusts you more than anyone else. And it's like, congratulations, but completely upending like their life gets upended. And maybe in a great way, maybe not in a great way. And so it's like really important to have these conversations with the people and ask them if they would be willing to serve in this capacity, what it would entail, given this terrible thing happening, and making sure that they're completely okay with it and on board, because once something like this happens, they are also going to be, everyone's going to grieve for you, but the people who then have to step up into that role and take charge have to be mentally prepared to do it.
Absolutely. So you definitely want to talk with your guardians, with everybody that you've appointed in any of these roles. But know this, you can talk with them and they can say, sure, I will do this in the event.
It's totally different when it happens.
Well, or let's say when it happens, they can't act for whatever reason. They're in a place where they're unable to act. Mentally, physically, maybe they're health-wise.
Things can change from the
things can
time you
change.
sign that initial
Yes.
document to later.
And they don't sign, right? You're signing that you want to appoint them.
That's
But
right.
when the time comes, if they are unable or unwilling to act, they can say, I pass, and it'll go to the next listed person.
Yeah.
So that's something to think about too. Maybe have a couple of people in line, kind of in order of priority. And then, in case something happens, you have a backup also.
Got it. The backup to the backup.
Yeah.
Right? Yeah. Okay, so let's tackle some more difficult scenarios. What special considerations come to mind in the case of blended families, right? Because we talked about this is your family, you, your husband, you have children, you're both making these decisions as a team, right? But when you have a blended family, that can be even tougher, right? Even under the best of circumstances, that could be super challenging. So, what are some of the considerations to keep in mind in a scenario like that?
So I would really encourage blended families to see an estate planning attorney, because there are tools we can use like trusts that, in my opinion, is just better planning. And so let's say, for example, in a blended family, maybe you have a support obligation. And so in the event that something happens to you, you have to fulfill that support obligation still, but you say, I still want my new spouse to receive, the bulk of my estate. And then but I don't want everything to go to my new spouse. I want also to make sure that, and then when my new spouse passes, whatever's left, I want to make sure reverts back to my child, because maybe the other parent isn't, I don't necessarily know if they're going to receive from that other parent, right? So it's really important to me to make sure that college or whatever is paid for from my estate. I don't want to, my new spouse to feel slighted, but I have a duty as a parent and I want to make sure that my child is also taken care of. So there's ways we can work through that and make sure that everybody gets taken care of.
Makes a ton of sense. So blended families, see an estate planning attorney. It's good advice. Yeah. So what are the biggest myths about wills and trusts? Because I think it feels scary to so many people, right?
Yeah.
What are some of the biggest myths?
Side note, I always love, after I finish doing an estate plan, I had this last week, and my client, he was this cute older man, and he was like, that really wasn't painful. And I was like, good.
It's worse than going to the dentist, right? For some people in their mind.
Yeah. Just do it. Start. Just start with that first conversation and see what you need. And, we don't try to make it too painful. And maybe you're thinking about it worse in your head than it really is. Honestly, what keeps you up at night, as a parent, that's probably worse than when you actually finally come meet with me and we talk through it and who's the guardian going to be and how does this work and knowing your child's going to be taken care of. And you're like, oh, okay, this can all get worked out. And that's why I'm talking to you. And now I can sleep at night knowing that if something happens to me, my family's taken care of.
Sure. I mean, it is, like I said, such a scary thing to be caught unprepared or off guard. I mean, so as scary as it may feel, and as, morbid as it feels to have to think about death, it's critically important that we do, because, as parents too, or as children, right, thinking about our parents, it is, you don't ever want to think about people that you love dying or you yourself being gone. And when you're alive, you want to do everything you can to give like every possible gift that you can to your kids, or even like in my case to my mom, right? She's 90 now. But I think that the biggest gift that you can give is, maybe not the biggest gift, but I would say a very important gift that you can give is actually upon your death. And I'm not talking about money. I'm just talking about planning.
Yeah.
So that the people who you love the most in the world are actually able to grieve, more fully, in a more like healthier way than if besides grieving, you're just caught up like in this whirlwind of uncertainty and fearfulness and I don't know what's going on. I feel like my world just crumbled, and even more so because now I have all these financial things that I didn't even know were there that I have to deal with. So you can't even grieve properly. And so, if you really love your family, which I know everyone does, as much as we don't want to face the thought of having to do these, planning or estate or trust or whatever, our powers of attorney, it is the best gift you can give someone is to allow them to grieve for you properly and take as much of that extra additional pain away from them in that moment. So
That's really well said.
that's why we did it, because I don't want my son having to figure out like these impossible things that he shouldn't have to figure out. And even once he's an adult, I just want him to not have to worry about all the heavy stuff. His parents did that for him. That is like a gift that we can give him now.
Yep.
When we are of sound mind and body
Yes,
still.
yes.
So now, like at what point does someone need to know exactly who gets what when they pass away? Because I think a lot of times we're like, these are my possessions. I want them to go to X person. How early is it that you need to know that? Or is it even necessary when it comes to possessions?
Yeah. And so in a will or a trust, we'll often include what I call a gifting form. Excuse me, a gifting form. And so that allows you simply to write if there's any specific gifts, like, my china to my sister. She's always loved it.
Yeah.
Whatever, this handbag too, my friend, whatever that is, right? And then by and large, though, most other assets, right, are usually going to go to like, let's say a spouse or your children and so usually it's just all part of the estate, like everything.
And the trustee decides, whoever you leave in charge of your
they help with
affairs.
it, but the trustee doesn't necessarily have to be the beneficiary. And so whomever you say the beneficiary is, so let's say I have a bank as my trustee and I have my spouse and my children as the beneficiaries, they're getting everything. And then it will honestly...
In what order though? So how does that work? So if you have your spouse and your children and they're all beneficiaries, who ultimately decides like where your necklace goes or
see.
You see what I mean? Like those types of possessions.
So really it would be
your kitchen table that somebody
between them
right?
to so assuming in this scenario, right, that they're all three equal beneficiaries. So if I say my spouse is the beneficiary and then my children, everything goes to your spouse.
Yeah.
Now,
and then he decides.
But if your spouse is, if let's say, he's not opposed to them receiving this item or that item, they're just decide among themselves what they're going to receive.
But what if there is conflict there?
No, there can
be. That's the thing, right?
Yes,
so that's the thing.
Yes. I mean, sometimes we flip a coin and each one picks a head or a tail, but I mean, I'm kind of joking, but kind of not. Sometimes I have a mediation background and I'm not going to lie, I've had to get involved over possessions and people having real
strong feelings about
who should receive what.
So I guess the best bit of advice is if you've already gone through the trouble of setting up these documents and you know that your one kid loves that specific table,
Write it
put
down.
it in the will.
Right.
Say this goes to this person.
Yep.
All the other stuff is just kind of like, let's hope they're not bickering over, again, material possessions. But at the end of the day, we've seen that happen over and over. There's been movies made over this, right? Books written about it, and the horror stories that so many people hear. But all right, so before we get into any kind of like a horror story, why don't you share with us, if you can, a success story of someone who had all their ducks in a row that made it easier for their family. You don't have to obviously share personal information of who the person was. Let's call them, Ann or Mark. But walk us through an example that you're like, man, this couple or this person did this so perfectly. I'm really proud of it.
You will almost never hear that story because they don't call me because everything was done right.
Yeah, but wouldn't there be someone that you had to deal with that's a trustee or something, and you're like, wow, this was awesome?
They call me, right? And I say, okay, here's the next steps. You're the trustee. Here's a list of things you're going to need to do. But honestly, let's say everything is put into the trust. All of the assets were titled correctly and the beneficiaries were named correctly. They updated their accounts as needed. And then they step in and they just start acting under the role it's all smooth. And they don't need to go through probate. One of the best compliments I get is when clients come to me and they're like, oh, that was easier than I thought it was going to be. And I'm like, that was the whole point of this.
Exactly.
And they're not really calling me. But conversely,
that's what I would done. Well, give me a horror story.
Okay.
So that we encourage people to do this.
Yeah.
Do it. They need to do it.
So there's lots of those stories, though.
But give us a good one, that will motivate people to
okay, so here's a horror story. Mom and dad didn't put wills in place or any documents in place. Under the state of Illinois, let's say you are married with children, and you pass intestate, and let's say the house is in your condo is in just my name. So I pass.
Again, passing intestate means you don't have
a will. Yep. Now the house will pass to my heirs, which would be my spouse and my children, but it'll pass intestate. And in Illinois, that means 50% of my estate goes to my spouse and 50% goes to my children.
Mm-hmm.
Now, the spouse has to be appointed guardian over their own biological children. Yes. Present annual accountings of how the money is being spent for the 50% of the estate that is for the benefit of the children.
Wow.
So now the spouse, in addition to, let's say, younger children grieving with the death of their spouse, having to raise these two children, they're in court, having to get guardianship over their own children to get access to all of the money and assets that the spouse left.
Wow.
For them.
Well, because they didn't put it in writing,
yes.
right? That the husband just gets everything and is, of course, entrusted to take care of their kids.
Yep. And that is a real horror story that I've actually dealt with and is very sad. It's very sad. And there's unfortunately nothing I can do at that point, except for, we can help them. We can help them legally in court, but it is what it is. The situation is what it is at that point. We can't undo that. We're going to be in court. This is going to be the process now that we're going to have to take.
Yeah, and you'll try to make that as easy for them as possible. But this is the whole point of that person was now wishing that they had in fact taken a day or two to put their things in order.
Yeah.
Yeah. Oof, that's depressing.
Yeah.
Yeah, so I'm glad that my stuff is in order. I pray to God all the time that I live a long and happy, healthy life, that I get to see my grandkids grow up, My kid's only 12, so he's like right in your ballpark of your age of your children. But nonetheless, the idea is you want to live a long, happy, healthy life and get to see all those things that you would wish come true, like seeing your kids grow up and seeing them get married and have kids and you being a part of that. But, life is a gift and, it's... They say, it's a gift because we live in the present, right?
Yep.
And it is like a present, but it could be gone tomorrow. So it's really important that we take care of the people that we love. And the best way, like I said, to show it is in making their life as easy as possible, not just in life, but especially in the darkest moment, which is on your death, should they actually love you and wish you were still around, which we would hope they do. Yeah. But so are there any new laws right now that should be considered with estate planning? Anything new that's changed that has made what we might have thought was the case before different? Or no?
There is actually a new law as of January 1st, 2025 that gives guidance to financial institutions of when they can reject powers of attorney. And that is an issue, honestly, that a lot of attorneys right now are dealing with. A lot of financial institutions are rejecting financial powers of attorney. Maybe they were put in place so many years ago, they don't know if they're still valid. This was, 30 years ago, and the financial institution is saying, I don't know that this is still, and I'm leery to let you step in and get access to this person's financial accounts.
What is the law? What does the law say? Like how many years back or?
Well, it's not that black and white, unfortunately.
Well, that's not good. Okay.
No, it's not good. But one of those reasons why a financial institution has less, how do I want to say this? Ability to reject a financial power of attorney is if an attorney certifies that it is a valid power of attorney. And so now I'm going back to former and existing concierge clients and saying, onto your financial power of attorney, we're just automatically adding on the attorney certification that I'm certifying this is a valid power of attorney. I met with you, we put this in place, this is who you wanted. Yeah. And so now you just have that extra layer of protection where a year ago, that would never be included. That wasn't there. Yeah. And now it's an important piece of paper to just add on to that financial power of attorney.
I'm going to have to do that for my brother because, my brother, he's obviously older than I, well, not obviously, but he is older than I am. But nonetheless, I am his power of attorney on all things, like financial, medical, you name it, because he almost died from COVID. He was hospitalized for 72 days before there were any kind of therapeutics or there was no vaccine at the time. He was a Chicago police officer and he lost both his kidneys, had 5 strokes during the first, he lost his kidneys like by the 3rd day of being hospitalized and within a month had 5 strokes and his life will never be the same. He obviously has a lot of memory issues as a result of the strokes and just such a horrible illness that almost killed him but didn't, but almost. And so his life is forever different and I have had to, take on the care of him in many different ways, including financial and healthcare power of attorneys. So I will have to change that, making sure that at no point is it ever an issue, because the whole point is it's when he's incapacitated or something that I need to really advocate for him. And can you imagine having the document and then showing up and getting, pushback would really be the worst thing that someone goes through.
Yes.
So. All right. Well, I'll have to be calling you, Cindy. Yes. But anyway, is there anything else that you'd like to add that we didn't cover, maybe that people need to know about this?
Make sure to update it, check in.
Oh, that's a good point. How often should you be doing that?
I mean, it depends on your situation. But
certainly anytime there's a different circumstance in your life, right?
It's not a bad idea at the bare minimum, once a year. Take a look at your estate planning documents. Are the accounts all still, maybe that bank merged? Is it still the same account number? Mm-hmm. Once you're gone, your beneficiaries and the people that you've put in these roles don't know how to get access to these accounts anymore. Sure. You're gone. They're gone almost with you, right? Unless you leave a list.
That's a good point because today everything is so digital and people have digital accounts, right? My husband went through this when his brother passed away. He was killed actually tragically he was riding a bike. And it happened so fast and like everyone's life changed. Everyone's life changed, not just my dear brother-in-law, Ben, but everyone's life changed. And David, as one of 9 kids, he's the one who took on the role, right, of serving in this capacity. Ben did not have a will. He did not. So it's like, it was a young, vibrant guy. You're not thinking anything's going to happen. But we've been through this. And as a result of that, right, is that like, we're like, we need to get our stuff in order. But passwords, like even getting access to passwords to your accounts. People think like, oh, I don't have that many accounts. You have way more accounts than you even think you do. People have no idea how many actual accounts, whether it's a Netflix or your Bank of America or Chase or multiple banks, right? Most people are always told never share your passwords with anyone. Your Facebook, Twitter, all your life is digital now. All of those things are things that need to be provided in an estate planning situation so that when that day happens, God forbid it does, the person who's responsible then for getting into your credit card statements, getting into all the things that tell the story of who you are and what your assets and liabilities are, has quick access to them. And that is something that you would say has to be in a document, correct?
So not necessarily passwords.
Okay.
And also that changes almost, you might change it daily, right?
This is true, but how do you get into someone's accounts then once they pass?
What we do is we put a clause in their will and or their trust saying that I'm giving authority to this person to access all of my online accounts.
Great.
And so everything from, LinkedIn to your bank accounts to all. And so then we have that and we say, no, we gave the trustee, or this person gave the trustee the power to step in and be able to access. And we list every kind of account we can think of.
Yeah.
And so we can then get access to that account.
So you could go, for example, to Gmail and say, we have this power of attorney, it says, or the will or whatever, it's got, we have the authority to access this individual's credit card statement.
Okay, so Gmail is different from, let's say, the credit card statement.
Oh, I
so
just made that up.
Yeah.
Sorry.
Yeah,
Threw
no,
you
that's
for a
okay.
loop
No,
there.
that's all
Yes,
right.
okay.
I like this. So,
but it's like personal emails and stuff.
Yeah,
And
but personal emails is another one. Actually, and those can be very important. And let's say there's a business owner, right? And it's like, hey, they have contracts to fulfill.
for sure, you have DocuSigns that get sent through an email.
So many things, right? Most of my communication for my business is in my email, right? And if something happened to me, my business partner would need to get access to my email to see what obligations,
Sure.
I have ongoing, all of that. So you didn't really ask me about this, but kind of segueing into each email platform has their own rules on if your trustee or executor can access the account upon death. And so you'd want to look into that. I don't remember what Gmail's is off the top of my head, but I can look into that for you.
Just making it up. But yes, I actually do have Gmail accounts.
Yep.
Yes.
But okay, so going back to, let's say, like your bank account, though, you did mention that, right? So, or your credit card statement.
Credit card statements, because you could have debt and you have to pay off those debts.
Yes, although I generally say don't worry about that because they will find the estate.
Oh, they'll find you for sure. Yes, you're right.
You don't have to worry about the
bank
creditors.
statements are a good one. Bank statements are a good one.
Savings account necessarily, knowing there's a life insurance
or like
policy.
a 401k or something like that.
Yep.
Any stocks.
Yep.
Things like that.
And so, hey, I have it, a Fidelity account. Here's my account number. Here's my contact at Fidelity. I have a Chase Bank account. Here's who my contact is. Here's my account numbers. Here, I have a checking account. I have a savings account. So they can go in online or in person, right, and say, okay, I need to get access to these 3 accounts.
Yeah. And then that would be done because it's been facilitated through that document.
Yep.
That you hire an attorney to do.
Yes.
So that's awesome. Wow, we covered a lot of ground today. And so I just want to thank you for joining us, both as viewers, but also Cindy, thank you so much for joining us today. I know I've learned a lot, and I think you've given us all a lot to think about. So I would urge everyone watching to, please start considering how you want your estate to be handled when you are gone, because these are details, like I said earlier, that no one wants to have to worry about hashing out after a loved one, even if that's you, has passed away. So get going. It's never too late to start. If you haven't, start now. And Cindy, actually, how do people get a hold of you? We will give it to us because we're going to throw it up on our podcast. If you're looking for a great attorney in this space, we wouldn't have her on the show if we didn't think she's awesome. So
thank you.
Thank you for being here. And I will see all of you next time for another episode of the Mendoza Podcast.